Welcome. My name's Ian Murray, and I'm a professor here at the WA Law School and chair of the Charity Law Association of Australia and New Zealand. I'd like to start by acknowledging that I'm dialing in from the lands of the Whadjuk Noongar people here on the banks of the Swan River in Perth. And just acknowledge that the Whadjuk Noongar remain the spiritual and cultural custodians of their land and continue to practice their values, languages, beliefs, and knowledges. I invite each of you dialing into this webinar to reflect on the traditional owners of the lands that you are dialing in from as well. Welcome, everyone. What I will do is introduce our four speakers, and then the aim today is we'll just run through each of the talks from our speakers and then have some time for questions at the end. And today's presentation on Equality Australia is part of the Charity Law Association's Cases of Note series, which is really largely built on the ACPNS at QUT charity cases publications. And when we get to Professor Myles McGregor-Lowndes, you'll see some links in his slides that take you to that sort of full suite of publications. So in terms of who we have speaking to us today, we have Emeritus Professor Myles McGregor-Lowndes, who is the founding director of the Australian Centre for Philanthropy and Non-Profit Studies and co-author of those ACPNS case notes that I just mentioned. Alice Macdougall, who's a special counsel at Herbert Freehills and has specialised for over 20 years in advising charities and foundations on tax structuring and governance, and has done a lot of work in the PBI space as well. Murray Baird, who was the inaugural Assistant Commissioner General Counsel at the ACNC from its inception in 2012 until 2019, and is now at Prolegis. And then Krystian Seibert, who is Executive Director, Policy, Government Relations and Research at Philanthropy Australia, but did a lot of work over several years working at the Productivity Commission on its inquiry into philanthropy. And as many people will know, there were recommendations in there relating to PBIs. So I'm interested to have Krystian's input on this as well. So what I'll do is I'm going to start sharing the slides, and Myles, I'm going to hand over to you to talk to us. Thank you.
Thank you, Ian, and thank you all. I'd like to also acknowledge the traditional owners of the land wherever you may be today. So go to the next slide, Ian. Just a quick promo. These case notes are aware can be accessed from the site here. We do short summaries for cases from Australia, New Zealand, United Kingdom, the more notable ones from the USA, and can be downloaded freely. Each quarter, we bundle up a short summary of all the cases. The third quarter, July to September 2024, has just been released, and of course it includes the Equity Australia case. Each case includes comments, and for significant cases such as this one, we invite people like Murray and Alice to provide their perspectives as well. Okay, and so if we can go to the next slide, let's get straight into it. Hopefully most of you may have read the case, but just as a summary, Australians for Equity was established in relation to the marriage equity debate which Australians had. It had charity status as advancing public debate. After the national vote, it morphed into Equity Australia with the new focus. The new focus was to improve the well-being and circumstances of gay, lesbian, bisexual, transgender and intersex people, and people questioning their sexual identity or preference, and their families and children. Equality Australia applied to be registered as a PBI, but this was refused by the ACNC at first instance, and then on the appeal to the ACNC. Equality Australia did not receive any government funding at the time, nor was there very much earned income, and it relied on donations and philanthropic grants. Of course, donations which received a tax deduction would be an incentive, and of course receiving grants from ancillary funds, you had to have the correct status. The primary judgment did reveal that the grants did come to Equality Australia through an arrangement with another suitably qualified organisation with the payment of a fee for auspicing. So there's a tip for young players there. All's not lost. You can often auspice, but you need to play by the rules of the game. And can I recommend Justice Connect have a very good section on auspicing for DGRs if you want to have a look at that. The next slide, please. So the ACNC argued that Equality Australia was seeking to change laws and policies for all LGBTIQ+. It does not constitute direct and immediate relief to people suffering poverty, sickness, destitution, helplessness, misfortune, or distress. Political advocacy and lobbying activities disqualify one from PBI status. This was despite the AidWatch case, and Kiefel J, as she then was, said it could scarcely be denied these days that it may be necessary for organisations whose purposes are directed to the relief of poverty or the advancement of education to agitate for change in the policies of government or in legislation in order to best advance their charitable purposes. No one would suggest that charitable and political purposes are mutually exclusive, but that was a charity case. I digress. The court questions were in the first instance were, did they experience distress as to be people in need of benevolence? And B, is Equality Australia organised to promote relief to these people? Next slide, Ian. First, the majority accepted that LGBTIQ+ people are persons in relevant distress, which may be relieved by acts of benevolence. It took expert evidence on this issue, which was well presented. Secondly, the majority found that Equality Australia's purpose was to address that distress by particular means, being, in short, advocacy. Thirdly, the majority found that the means selected were direct to achieving law reform. And fourthly, the majority found that this law reform may in turn relieve the distress of LGBTIQ+ people. Next slide, Ian. There had to be a sufficiency of connection. And this is the main point which Murray and Ellis will talk about. So EAL appealed, and I might point out here that this was pro bono. Well done, those practitioners who bore the cost and stress of doing this on a pro bono basis and counsel. Yeah, we get very few cases coming, and the lack of test case funding is to be regretted, as back in the Word days. It's also got to be noted that the ACNC played their part in this in not claiming costs if there was an adverse decision. So well done them too. There are the three areas of appeal. It went to the full court from the AAT, and Murray will describe further why this was so a little unusual, but it was of such significance and it was pro bono, so it was appropriate for it to be heard by the full court to get a finalised decision of important matters. So it was on whether the facts they're entitled to be a PBI, whether the tribunal misconstrued the expression, and whether the tribunal erred in law. So Ian, the next slide, please. The ACNC argued that Equality Australia's advocacy and policy developments do not provide direct relief or sufficient direct relief, nor is there a sufficient connection between its activities and the benevolent ends it pursues. Equality Australia's activities were directed toward achieving law reform, And in this respect, they were not sufficiently targeted to relieve the distress of the people actually in distress. EAL's activities were inherently preventative in nature and hence not those of PBI. And as the court would be asked to adjudicate an essentially political question, raises the whole English strain of issues about whether they can properly determine that matter. Very wide grounds there. Okay, next slide, please. Let's go to what the full court found. The majority recognised that there was a logical connection, but recognising a connection of that kind does not lead inevitably to the conclusion that Equality Australia activities were sufficiently connected with the relief of distress. It was a matter of a question of fact and degree to be decided by the tribunal's view of all the circumstances. The tribunal had done this and reached a factual conclusion that it was open to it as a matter of law. So very much we can find no error, and the tribunal could have reached that conclusion. So very much hands off. So Murray and Ellis will speak of the means by which they got to that, but it involved a Thorley case. My quick comments. Time. I'm always eager to look at the time that these things take to go through the process. 4 years is not overly long, but still a long period to be in limbo. Costs, which I've already mentioned, they're just so sensitive in these matters, and we really need proper official test case funding to get the flow of cases through the courts in order to clarify the law appropriately. The ACNC's arguments were not dealt with in any detail by the full court, having decided on other matters. And I would suggest that the present Commissioner's interpretation statement does have things to say on PBIs and prevention and PBIs and advocacy. And it could be seen that their contentions may be in contradistinction in that case to what they've put in the CIS. So I guess I'm waiting on some clarification of that, and I think they've indicated that they will review their CIS. The other point to note here is whether, having made a Commissioner's interpretation statement, when you get to court, it's all off and they'll start arguing not in accordance with the CIS, but from other grounds. I find that a bit perplexing, frankly. And the final point that I would make is the auspicing workaround for practitioners who want to help their clients. It may be a way to achieve achieve a flow of donations in any case, but it needs to be properly done and not merely a free-for-all channel. So Ian, I'll conclude there and hand over to Murray. Oh, Alice. Sorry, Alice.
Thanks, Myles. That's fantastic to get the facts out there. I'm coming to you, hi everyone, from the land which always was and always will be the land of the Wurundjeri people, the Kulin Nation. I've embraced the changes that have occurred to the interpretation of PBI over the years. When I started in this area, it was very much about direct relief. Simply the entity needed to be running the programs and seeking to provide relief directly. And no, I didn't start work in this area in the 1930s, but that was clearly still the way PBI was being applied 20 years ago. Then momentously, Hunger Project recognised that benevolent purposes could be delivered indirectly by PBI. And more recently, we've had some cases considering activities of entities with benevolent purposes which are pursued indirectly. And the cases seem to have raised what seems like a new requirement of sufficiency of connection. But to be clear, the cases tell us this is not a new requirement. It is just inherent in the ordinary meaning of benevolent. And the expression PBI, they recognise, can change and evolve over time. This, I think, is meant to be comforting. Next slide, thanks, Ian. So, the elephant in the room is that we all know there's no ordinary meaning of PBI. But the judges seem to persist in pretending that there is, and so we have to resort to their interpretation. Well, I've got to say that I have wanted to consume variously, since this case came out, significantly, or perhaps a sufficiency of paracetamol or vodka, or sometimes both, trying to work out something that apparently is not new and apparently is an ordinary meaning of an expression. I don't know why we're wasting our time on this, really, Ian. It's meant to be clear. Next slide. So a PBI is organised, conducted or promoted for benevolent relief, which is taken to mean the relief of poverty, sickness, destitution, suffering, distress, etc. These recent cases also tell me that to be benevolent, and this is something inherent in the meaning of the word, we must look at the activities and consider if there's a sufficiency of connection. So how and when do I apply sufficiency of connection? The connection between the activities and what exactly? And is PBI now an activities test? And where is this magic line? What would be sufficient? It sounds very subjective and a bit like it's the vibe, Your Honour, which, as we know from the tribunal's earlier decision, one person's vibe is different from another. And as it's a question of fact based on ordinary meaning, what scope is there for the ACNC to give us a broader interpretation? Next slide, thanks. So the question of proximity or sufficiency of connection only arises in relation to indirect relief or indirect activities. And this comes from a comment by Thorley in the Australians for Indigenous Constitutional Recognition case, where he says the more abstract and less direct an institution's activities are for the relief of poverty, etc., the less likely the entity is to be regarded as a PBI. In Global Citizen, they said this comment was undoubtedly correct, and then said that where the entity does not provide relief directly, but relies on providing relief indirectly, there is likely to be a spectrum, and it is possible that the activities of an applicant will be such that it's not possible to say the entity is organised for or concerned in or promoting the relief of poverty. So this test, we know now, doesn't impact where an entity is undertaking activities which are aimed at providing relief directly. It is clear when conducting direct activities to provide relief, the PBI just needs to have a reasonable expectation that the activity will provide relief. So where the activity is aimed at providing relief indirectly, what connection do we need to establish? Is it sufficiently connected to actual relief or sufficiently connected to an activity which is aimed at providing direct relief? The first option would require us to prove impact, which has never been required before and is not required for activities seeking to provide direct relief. And it doesn't seem inherent in the descriptor of organised, conducted or promoting relief. So in fact, Equality Australia, they stated that built into this formulation of organised, connected or promoting relief is the idea that PBIs pursue particular aims by means that bear an appropriate relationship to those aims. And in Global Citizen, the cases, they said, the cases do not suggest it is necessary to require proof of the link between the activities of the entity and the provision of relief. So we know we don't have to prove actual impact. We also know from the Hunger Project case that fundraising activities to give existing entities which share benevolent purposes will satisfy the PBI requirements. The activity of raising funds and giving it to other entities is sufficiently connected to the activity aimed at providing relief being conducted by other entities. There's no requirement to assess the reasonableness of the fundraising prospects or to assess the impact of the activities aiming to provide relief. The intention seems to be that there is a sufficiency of connection between the activity of the entity, e.g. in that example, fundraising, and the activity which aims to provide the relief, e.g. the programs aimed at providing direct relief of hunger. If there is an activity which aims to provide relief in existence, then this connection is satisfied, I would say, regardless of how far down the chain or the continuum the entity is. In Equality Australia, there was no activity that was currently aiming to provide relief. This activity to provide relief was intended to be brought into existence by the change in the laws and policies. Though it wasn't spelt out as much as we would like in the judgment, it seems that there were too many uncertainties in order to bring into existence the activity intended to provide the relief, and uncertainty as to the content of the changed laws. And it's perhaps because of these things that it failed the sufficiency of connection requirement. So what I've tried to do is think of another context where this could apply, and I've gone back to the fundraising type of example. So what if an entity intended to fundraise to build a community hub for benevolent relief providers to occupy? The operation of the community hub is the activity which is aimed at providing relief through the support and collection of service providers in one place. It may be possible that the sufficiency of connection test would come into play depending on how realistic it is that the entity would be successful in establishing the community hub. The uncertainties that exist could include whether the entity has the land or not, has the necessary council approval or not, has plans drawn up for it, has some indication of the significant funding it would require, or support from identified local service providers. What level of certainty that the hub would actually be built and inhabited by service providers and therefore be providing the relief would be required to enable this entity to be a PBI? Is the sufficiency of connection actually an assessment of how probable it is that the activity providing the relief will occur? Well, this seems to be similar to the tests required for other DGRs with activities tests, being a health promotion or harm prevention charity, where the activity cannot be too remote from the outcome desired. Next slide, thanks, Anne. This is where the ACNC comes in to assist us. And I think that it's really essential that the ACNC makes it clear that no proof of impact of the relief or the relief is required, whether the activity is direct or indirect, because that is clear, and I think that is a concern that has been raised in relation to this judgment. And that this sufficiency of connection consideration only arises when there are many, many steps required to bring into existence the actual activity which is aimed at providing relief, not when there is already an activity that's providing relief. And to help hopefully give us some indication of where the line of sufficiency is. For advocacy, how far down the legislative process does the change of law or policy have to be in order to pass that line? And then, most importantly, I think, not most importantly, but I think there's a significant opportunity here for the ACNC to go, okay, well, the courts keep telling me that this is an ordinary meaning of PBI. And in current modern understanding of benevolence, it would definitely include prevention. Prevention is the most effective way of addressing benevolent needs, to address the cause and stop the distress. It should be included as part of the ordinary meaning of PBI. I think just a couple of other points the ACNC could look at, make it clear that it doesn't change the ability of PBIs to pursue advocacy as part of their benevolent activities. And that any activity may be benevolent, and that could include environmental activities, cultural activities, advocacy, research or education, provided it meets the not new test and the ordinary meaning of PBI. Thanks, Ian.
Thanks, Alice. And I echo your acknowledgement of country from Wurundjeri lands. Before making my substantive remarks, can I comment on the process of this appeal? Ordinarily, an appeal from the AAT would go to a single judge of the federal court. However, there's a provision in section 44(3) of the AAT Act that a matter may go direct to the full court where the AAT panel includes a deputy president and where the Chief Justice of the Federal Court, after consulting the president of the AAT, refers the matter direct to the full court. And I understand that the reason this case apparently leapfrogged to the full court was under that process. And with respect to the parties and to the court, this seems a sensible and efficient process, particularly where the solicitor and barristers, as Myles has pointed out, are operating on a pro bono basis. We'll go to the next slide. Now, our understanding of the expression public benevolent institution starts from that principle that it bears its ordinary contemporary meaning. And that meaning is a question of fact. Applying that ordinary meaning to a particular entity is a question of fact. And that was the first hurdle for Equality Australia to overcome, to demonstrate the appeal requirement of an error of law. The court spent most of the first 8 pages of its judgment on this issue. So to take the meaning and its application outside a question of fact, the appellant must show that the decision maker was unreasonable or applied the wrong legal test or added a meaning or qualification of their own. However, the term public benevolent institution doesn't appear in any authoritative dictionary, although public house, public spirit, public convenience, public school, public enemy, and many other things public are defined. So we come to the next slide and the search for the ordinary meaning. How does one establish an ordinary meaning in the absence of an authoritative lexical source? Here are some clues. The sense that it's commonly used in the English language, one's own experience with little help from dictionaries, statutory usage or judicial decision, how it is currently spoken of in English language, and it is not a technical meaning. A decision maker might be forced into the street to ask ordinary people what public benevolent institution means. My own unscientific survey of taxi drivers in the cities of 3 eastern states evidences a much narrower understanding of the term than any lawyer would contemplate. We'll go to the next slide. Yet the court in Equality Australia was confident to assert that there are traditional concepts of benevolence informed by court authority. Although the meaning is an ordinary meaning and not a technical meaning, we're not sent into the streets to assemble expert evidence vox populi, but we can discern the meaning from the way the courts have understood that term, making allowance for the evolution of the meaning. I think the lesson of Equality Australia is that it's open to the decision maker to apply their own understanding of the term, as long as they don't do so unreasonably or add their own meaning contrary to court authority. It's a wide remit and permits a qualification of sufficient connection, another concept subject to subjective impression rather than objective meaning. And it's worked out on a case-by-case basis. However, the scope of that sufficiency of connection may well depend on the posture of the decision maker, who is standing at the gate as the gatekeeper to tax preferment towards benevolence. So the next slide asks, what do we know? Well, we know that from this case, that there must be a needy cohort. Is any group in society so notoriously disadvantaged as to be a suitable target for benevolence? Or should there be a granular examination of individual needs within that cohort? Would a food pantry open to all members of the community be an invitation too wide to come within the PBI concept, even if the sponsors of the food pantry did not want to stigmatise people for stopping their car or walking by to take bread? Secondly, the sufficiency of connection test is with us following Equality Australia, and there will be an examination of activities and results in addition to purposes and aspirations where direct doing is absent. And thirdly, advocacy in the wider community for social change in itself will apparently be an insufficient connection. So if I can come to the big question on the next slide, is this a purpose or is it an activity test? You'll notice that the first 12 subtypes in Section 25 of the ACNC Act require a charitable purpose. But subtypes 13 and 14 are the odd ones out. No purpose is described. They have a different test. HPC is expressly an activity test. PBI is an organised, promoted or conducted for test. That's a test that goes beyond mere purpose to examine activity. So ACNC describes the examination as taking a holistic view. It could be described as taking a hybridised examination. But the Full Court in Equity Australia makes it clear at paragraph 100 that the relevant inquiry is no longer merely a purpose test. We're left with 3 unresolved matters. We'll go to the next slide. 3 matters that remain unresolved are the Commissioner's contentions that the Court didn't consider because it wasn't necessary. Is advocacy, education and campaigning a disqualifier? Can a defined cohort generally in need of relief be a sufficient target for benevolence? And is prevention part of an evolved understanding of benevolent relief? We'll await the decision impact statement or the revised CIS from the ACNC to see what the Commissioner's view on these important matters is. But I'll leave the last word to Professor Anne O'Connell, because I began with the meaning of words, and some ideas may go deeper than adequate words into the deep magic of PBI. From Professor O'Connell's decision in the AAT, quoted, without disapproval from the full court, a characterisation process which does not set out express criteria invites the decision maker to stand back, review the stated purpose and activities of the organisation, and make a broad evaluative judgment as to that organisation's essential nature. The evaluation must be objective and it must be evidence-based, but it ultimately involves forming an impression. One just knows whether something meets a definition when one sees it. So, Alice, indeed, it's the vibe. Krystian.
Thanks, Murray, and hard act to follow, those 3 speakers. Great to be on the panel with you, and thanks to Ian and the Charity Law Association for organising it. And I'm coming to you from the lands of the Wurundjeri people of the Kulin Nation. I want to pay my respects to the elders past, present and emerging, and also acknowledge the lived experience amongst participants, but also that lived experience is really important to this particular topic, because what we're talking about today is very closely linked to the lived experience of many Australians who are LGBTIQ+, who have faced systemic discrimination over a long time. And it's not actually just about tax law. The decision sort of makes various comments and observations which are, directly relevant to that lived experience. I think it's really important to hold that thought when administering a regulatory framework as well. So I just thought I'd make that point. But I'm going to just, make my comments a bit higher level, drawing on some of the experiences and thoughts that I had during the Productivity Commission Philanthropy inquiry, and just mentioning a couple of the relevant recommendations there. I think it's important to recognise, or at least this is my view, that although this decision and our discussion is about the definition of public benevolent institution, it's also, and perhaps even more so, actually about the scope of the DGR system and how the system has gotten to where it is. Because Equality Australia was seeking PBI status primarily to access DGR status, noting that there was a workaround available to them, rather than, say, for example, the FBT exemptions that also come with PBI status. And we all know why the DGR system is where it's at, and we know that it has various gaps and holes. So this isn't just about PBI, this is also about the DGR system, because those questions around prevention, advocacy, they're very rarely relevant in a discussion around the DGR system. And a lot of the pressure on fitting into the category of PBI is because there aren't any other categories available if you're focused on prevention of disadvantage or advocacy in that context as well. And the case wouldn't actually have been necessary had, and this wasn't possible because governments don't operate that fast, but had the Productivity Commission inquiry's report recommendation for DGR system reform been implemented, Equality Australia, similar organisations would be eligible for DGR status if that recommendation had been implemented, or the recommendation of the NFP Sector Tax Concession Working Group over 10 years ago. We've been holding our breath for a long time for reform of the DGR system. So I think that I wanted to make that comment that this is actually about the DGR system as well. And, we have choices about where that system can go now as a result of the recommendation from the Productivity Commission inquiry report. Obviously, the government and the Parliament make those final choices. The Productivity Commission inquiry report also recommends a legislative definition of PBIs. And I know that there are different views on that. But I do think that we have an issue whereby a term that carries so much weight with it has no legislative guidance about what it means. And we end up in a situation where the courts and regulators are effectively having to make policy judgments, which I don't think is their role. That's the role of governments and the legislature. Whether prevention or advocacy is part of the ordinary meaning of PBI is essentially, there's a lot of policy judgments in that sort of a question. And going to Alice's point earlier, I think was a really good one around, there is this situation that we're all acting as if there is an ordinary meaning, or if it's self-evident, and then the courts are kind of pretending that there is one. And what you said, Murray, I am tempted to sort of maybe start asking Uber drivers, and I'll see if they've got a different view from taxi drivers about the ordinary meaning of public benevolent institution. And then, I'll see, I wonder what their views will be about sufficiency of connection and that sort of thing. And I think we need some humility here in all of us, including the courts and regulators, that we're almost pretending like there's an ordinary meaning of PBI here when there isn't. And you can also have different people with different views about ordinary meaning. And that goes back to the point I said earlier about that there are policy judgments here, and there can be different views and different perspectives. And that's one reason we have a legislature, to help look at these different views, make judgments, they don't have to be the right ones, around where things land, to try and effectively arbitrate some of those different perspectives, provide more clarity. That's the role of the legislature. And I think just on that point around sort of some humility around the definition of PBI, it's not like the definition of charity that has evolved over centuries and has an existence irrespective of statute, whereas PBI is grounded in statute, and it effectively exists in statute by accident because of a Privy Council decision in Chesterman and the Parliament of Australia responding to that in 1927, and then the Perpetual Trustee case onwards, all those cases having to interpret a definition that would not exist were it not put into statute nearly a century ago, which brings me back to the point I made earlier around, there's DGR system reform, which would address many of the issues, but also the Productivity Commission recommends some legislative guidance for the definition of PBI because of these policy questions, because it does exist because of statute, but there is no guidance. And we may be here for a very long time if we're trying to resolve a lot of these questions that we have. And I'll finish up now just to allow time for discussion and questions. Myles mentioned test case funding, and the Productivity Commission inquiry report also recommends that test case funding be provided to the ACNC, and it's not the first report to recommend that. But an open question, would it actually assist? Or could the ACNC, for example, argue, well, this decision's provided a lot of clarity regarding the definition of PBI. That's our view, so it's not something that needs further exploration through the courts. I mean, it may adopt a different view, but I think that that could be one of the challenges. But I do think that this is obviously a very complicated area. I'm looking forward to see what the Uber drivers think. But going back to my point earlier, that there are a lot of policy judgments here. This is something grounded in statute, the definition of PBI. I think it would be fitting for the legislature to provide some guidance about what it exactly means, help resolve some of these questions, noting that won't answer every single question, but also we can resolve a lot of these questions just through DGR system reform, noting that that's not easy either, but need to keep trying. Thank you.
Thank you, Krystian, and thank you very much to all of our speakers, and they've done very well keeping to time, which means that we've now got a good 17 minutes of time for people to ask questions. And I see we've got a couple of questions in the chat, so I might just go to those first, and then people online can be thinking of other questions in the meantime. The first question, I think, was directed mainly to you, Murray, challenging your statement that we know that advocacy without more is insufficient. Do you want to respond to that?
Bridget, I do accept that critique. I think, and I accept the fact that this was a decision of fact in the first instance, and the appeal court simply said it was within the range. What I think the implication is that decision makers in the future will, as a practical effect, apply the sufficiency of connection test, and therefore advocacy without more, that is, without sufficiency of connection, will be generally seen as a disqualifier. Now, whether that is right as a matter of law, I think it's probably what's a fair prognosis as a matter of fact. But I'd love to have a debate on it, and I also accept your views on that.
And we've got a question. Well, maybe before we go to the other questions, let's just pause and check whether any of the other speakers, panelists, want to add to those comments of Murray. I guess bearing in mind here that the Advocacy Inequality Australia was all about lifting the potential cause of the discriminatory treatment by the state against LGBTIQ plus people. So it's sort of hard to see how you'd address that without advocacy to change the law in the first place. So just interested, do any of the other panelists have anything that they wanted to add to Murray's comments?
I think in my analysis that you can have an advocacy body that meets the sufficiency of connection test, but it's where that line will be. It's like it's almost like how realistically is the change in law going to occur, and then the law itself actually address the things that are causing the distress. So do you need to have a bill that clearly addresses those things and a certain amount of support in relation to that bill to say, yes, there's a sufficiency of connection? I think it's definitely open. I would say it's not closed if all you're doing is advocacy. But I think it raises the other question too is, well, how much other stuff do you need to do? Like, what are the proportions? You know, that there's a lot we don't know in relation to that.
Thanks, Alice. Myles or Krystian, any additional comments on that?
Well, I think it should be pretty straightforward that if you're undertaking advocacy and that's that's one of your charitable registration subtypes, you should have DGR status. And like I said in my remark, I think it's actually not that. It doesn't need to be linked to the definition of PBI, and that's sort of the approach that the Productivity Commission inquiry report took. I think sort of we then are forced to kind of come up with a lot of these complex kind of scenarios and questions and analytical frameworks to address this, to try and fit it into the definition of PBI. And also noting that, where you draw these lines and boundaries is really tricky, as Alice said.
Well, we'll leave the FBT elephant happily in the room for the moment, and perhaps move on then. The next question we've got in the chat from Fiona Martin is about whether it's a good thing for the ACNC to be able to depart from comments in the CIS and make other arguments, given the extra thinking and input that goes on at that point. So I don't know, and we've got, I think, several people from the ACNC on the call as well who may wish to comment on this too, but I'd open it up to the panel to start off with. Just thoughts on, I think, Myles, you had raised departure from the CIS. I mean, that was a classic ATO approach, even with ruling sometimes as well, but just your thoughts on that, the pros and cons.
Yeah, listen, I note that this is not, CISs aren't in the same league as ATO rulings, and so forth and so on, and restrictions. But I would point out that the English Charity Commission of England and Wales in the early 2000s did go out and redefine, reinterpret a number of the charitable purposes and include various activities that were borderline and purposes as charitable. And these were later picked up and agreed to by the courts and in legislation. So given the scarcity of cases in Australia, the regulator is in a very powerful position to shape the practice of charity law in Australia. Now, if it doesn't believe in its CIS itself is the reflection of what it believes the law is, in my view, that creates a great deal of instability in the meaning and in the interpretation of the law. So I can see Fiona's point, and of course they, I guess, under the current regime, they're free to depart in appropriate circumstances. But this was a wholesale departure from their CIS in my reading. So I was a bit surprised at that. And if I was on the other side, I'd feel a bit miffed that, you've got the CIS, you thought you knew where the regulator was standing, and then to have to meet a completely different case of at the very basis of prevention and advocacy, I think is quite destabilizing, and particularly in the future. So I really hope that the ACNC, one way or the other, says that they are or they're not going to be bound in future cases about this. So at least we're all clear on that. I hope that they say that we have sufficient belief in our CIS to believe that it represents a good reflection of the law and how it's to be applied. That's my personal view.
Thanks, Myles. Murray, you look like you'd like to add something.
Yeah, I agree with Fiona that the Commissioner is entitled to put whatever submissions to the court to test areas of law. Then after the case, I would hope that the decision impact statement or a revised CIS would tell us now, in the light of the decision, having made the submissions, what the Commissioner's view is now, lest we assume that the submissions are the Commissioner's view.
With respect, Murray, the ACNC isn't acting as an Attorney General as a contradictor in cases where there isn't two sides who are having a good argument before the court. And I think it'll only lead to instability. Of course, under the present regime, they're entitled to do that, but I think it leads to instability. And they should have the courage of their convictions. If they say that this is what they believe the law is and a reflection of how the law is to be applied, then they should try to stick to that where it's all possible.
I totally agree with that. I find it really unsettling that ACNC would argue things differently than the CIS. I mean, the page on the website says the CIS is how we understand the law that applies to charities. So that one of them's incorrect. Either the CIS isn't how they understand the law, or they're going to the court arguing things which is something that they don't understand is the law. So I find it really unsettling that the ACNC could say this is what we think the law is and then go to court and argue something else.
Now I'm just conscious we've got Joanna and Sahanya on the line as well. We've sort of heard some perspectives on this. Do either of you want to comment from an ACNC perspective? Well, only if you'd like to.
Hi, everyone. I probably won't comment in detail today. I don't think that would be appropriate. I would say, though, that we're looking forward to sharing I think I can say now that we're looking forward to sharing a draft DIS, and we're going to seek some feedback on the DIS, and we look very much forward to receiving that feedback from the group. But I'm not going to comment on anything else, but I'm listening and we're taking notes, and we'll certainly take this back. Thank you.
Excellent. Thanks, Joanna. So that's good. So we haven't killed off CISs and DISs from the ACNC with this discussion, hopefully then. Now we've got Gilbert and Tobin, I can see on the line, and I know Darren had flagged to me beforehand that he or Michelle might have some comments they wanted to add in. So I might just check. Darren or Michelle, are you there? And did you want to comment on the panel's discussion on or ask questions on the Equality Australia decision?
Oh, thanks so much, Ian, and hello, everyone. I think just firstly, thank you, everyone. Thank you to CLAANZ and thank you to the panel. It's been a really insightful sharing of various views from lots of different perspectives. It was Gilbert and Tobin's pleasure, I guess, on a pro bono basis to assist with the case, and with Jennifer Petrowny acting also pro bono. And I'm not sure if Jennifer's with us, but thank you, Jennifer, publicly for all your support, and to the co-counsel that assisted all of us. I really, from a technical basis, can't add too much more than what we've heard today. I agree that we need to consider the DGR context in a broader way, and one feels sometimes that the views of a particular person or bench are sort of contorted in such a way to, maybe mangle the law on the way through to achieve an outcome which need not be mangled if there was another way to that same outcome, say through a reformed DGR process. I am bemused by what is the common meaning of PBI, like the panelists have suggested. It is not something that we, would talk about regularly. I certainly don't mention PBI or talk about it very often when I'm having dinner with my children. But where does one turn? And we hear that it is a statutory term. I agree that if we do not get DGR reform, and we do need to give greater clarity around prevention, then perhaps that's a legislative mechanism to speak about that in more detail. So really nothing too much more to add from what has been, I think, a very insightful and helpful discussion from everybody.
Thank you, Darren. I see we've got one more question in the chat as well from Dan Saunders. And it's Murray. I'm interested in the idea of prevention as a possible expansion of benevolent activity. Would have been good to hear the full court view on this. However, would not the harm prevention charity type be a better place for such an expansion?
Yeah, thanks, Dan. It appears that the policy reasoning for introducing the health promotion charity was to have the opportunity of getting over the perhaps caution about prevention in the PBI area. But we know from the PBI CIS that in some circumstances, prevention is an aspect of giving relief. And then we have the old adage that prevention is better than cure, and the stories of ambulances and fences on cliffs. I would submit that in the PBI area, the public would expect that a PBI doing its job would pay as much attention to prevention as cure, and that if they put more emphasis on prevention, that's probably better than putting the emphasis on cure. So I think it falls squarely within PBI, and it's difficult for someone to interpret the CIS when it says in some circumstances prevention could be allowed. I think it'd be good if the regulator could come out and tell us in what circumstances is prevention allowed, because I think it is part of the contemporary meaning of benevolence.
Thank you, Murray. Alice, Myles, or Krystian, did any of you want to comment on this?
Great.
No? No, we've probably got time. Oh, we have got another question. So Luke Hall's posed a question. Does the sufficiency of connection test place a stopwatch on charities, PBIs undertaking their work? So in the international aid and development space, there's a recognition that genuine relief takes time to implement. And I guess, Alice, this is probably more for you and your comment about, I'm hesitant to bring back the word concreteness, but I think that's sort of where we're going with this, you know, the level of specification of the actual impact that's going to, or the activities that are going to lead to that impact. Did you want to comment on Luke's question?
Sure. I don't think it does mean that you've got to have stopwatch in relation to it, because I think the issue is that there's a reasonable expectation. It's the same test as charitable purposes in terms of your activities. You've got to reasonably expect that they further your purposes. You've got benevolent purposes. And so it's a governance obligation, really, that you're talking about there that says, well, how long do you go on trying before you decide it's not working or that changes need to be made? And so that's why I think it's really important that the ACNC is very clear in its DIS that this is not in any way requiring a timeline or proof that relief is actually occurring or that there's sufficient impact, because that's covered by your governance obligations anyway in the requirement to be furthering your purposes. I do agree, though, that the way it's expressed, and sometimes in places in the judgment you could read that, which is why it's so essential that the ACNC says, no, that is not the way we're interpreting it. And I don't think in any way that was what was intended.
Thank you, Alice. We probably should finish up in a moment as we're 1 minute past, but can I just check whether any of the other panelists wanted to comment on that as well? No? Well then, if everyone can just please join me in thanking Myles, Alice, Murray and Krystian very much for sharing their insights with us. And if people would like to access the recording of this presentation, it'll be sent out to everyone who's registered for this, and then also available for members as well. Members should receive a link to it. So big thanks to everyone. Krystian will be happy to know that after reading 60 assignments on PBI and Productivity Commission's DGR proposed reforms, about 3/4 of the students would like a legislative definition. So
great students there, excellent students.
So thank you everyone very much for logging into this. And our next event, we'll be hearing from our next CLAANZ event, that is, we'll be hearing from Myles talking to us as part of the CLAANZ annual lecture and Emerson oration. So big thanks to all our presenters, and I hope to see everyone again soon. Thank you.
Thanks everyone. Thanks, Ian.